All right, hello everybody. My name's Richard Martin. I'm an anthropologist at University of Queensland, and I think this talk will hopefully complement Jitendra's presentation. I'm talking about the issue of succession which popped up in the Kutcha claim in the Gulf country, the southwest Gulf country, which was litigated a couple of years ago now. So it's not completely front of mind for me, but hopefully as I talk, I can bring it back to life. So just a bit of background about Kutcha people, a map here. So looking at the country sort of north and northeast of Normanton there, my research began unusually really with the preparation of the genealogies for the group and their neighbours, which allowed me to get to know them really well prior to doing the connection research. The claim was lodged, lay evidence was heard, and the expert evidence in early 2020, just as they were putting up signs in the federal court building about social distancing, we got through that expert evidence, thankfully, before all the curtains came down. Judgment of 2021 is worth reading. I think there's a lot of lay evidence that's quoted in the judgment that I'll draw from briefly here. I asked my students to review a native title judgment in one of our anthropology courses, and I'm sure all the lawyers in the room are used to reading judgments, but I do emphasise and encourage our anthropology colleagues to do so also, and this one I think is an interesting one. There are ongoing claims by Kutcha people and their neighbours, so which I won't address, but I'll try and confine what I have to say to the claim. So there were a number of issues in the matter, of course, but one of the principal issues was the issue of succession. And from the summary here, whether it was necessary to prove actual process or other facts to establish licit succession, or whether incoming claimant group to native title rights and interests of extinct groups, whether sufficient spiritual correspondence between traditional laws and customs of the extinct and the claimant groups, and where there was disagreement on indicia processes of licit succession between myself and some of the other experts involved in that matter. And then this last point, which became critical, about the confidence in the connection to country and ability to manage its spiritual powers and dangers. So Normanton, there's not been a lot of anthropological research there in contrast to other regions, but we were fortunate that Laurie Sharp, the American researcher, came down and left some field notes, although he was fairly disparaging actually about Aboriginal people at Normanton. You can see there, I think that's from a footnote in one of his articles. But he didn't spend much time there. He came down on horseback from the region where he was working to the north with what he called the Yirront people. Tyndale, of course, visited the town, Normanton, and other parts of the Gulf country, and he spoke briefly to people there. And Peter Sutton came up in that language survey run by the Institute through northwest Queensland in the early 1970s. Gavin Breen did lots and lots of interviews and language research with people, particularly to the west of Normanton, and Paul Black, another linguist. Black worked extensively with Rolly Gilbert and others, and their work helped to secure the purchase of a cattle station for Kutcha people, which became a real hub for that group. And but as a result of some legal complexities, which I won't and probably can't explain, it was unable to be claimed. So in contrast with some regions where I think the core country, so to speak, or the central areas where perhaps the strongest evidence tends to be claimed first, in this instance, the ownership of Delta Downs in terms of the ownership of the lease raised some issues to do with capital gains tax, as I understand it. So that was left out of the initial claim, which was then to country to the, outside that lease station. There was some research in the context of the Century Mine Agreement in the 1990s also, but Koodaidji people weren't a signatory to it. Just briefly to honour and credit and thank the Koodaidji people who participated very extensively in very lengthy and difficult and really ongoing research. Irene Pascoe, Lance Rapson, there sitting on the cattle fence, and Joey Rainbow, who gave his name to the to the applicant. So I was lucky that I was working with people who'd spent a long time, much of their lives, actually living on country or adjacent to it and working on cattle stations, so they knew the country, and particularly Warren Beasley, who had been all over the country as a cattle person and spoke Koodaidji and knew hundreds of place names, extensive knowledge of areas, and it was very fortunate to have access to these kinds of people. But it's an interesting case study coming after what we've heard from Jitendra, because it's looking at succession outside that Northern Territory context where where we have such rich data and such wonderful history of ethnographic research and so on. In this example, we see the problem really clearly put in a map prepared by Paul Black, the linguist, in the 1970s and 80s, which depicts a boundary or a line that was well to the, it was problematic in the context of the claim, suggesting a language boundary to the east of the Koodaidji claim area. There were other ethnographic sources which contradicted that depiction, but it nevertheless suggested that there were other groups or there were other labels that had been recorded in the country over time. And of course, Tyndale introduced similar complexities, and you can see here the map that he produced with his idiosyncratic and unfortunate spelling, difficult for people, which tends to depict the claim area as that Wollongumma area. You can see there to the east. So, these were complexities that had to be confronted in the context of the claim, which was litigated. So, how do we approach this? We know that Tyndale's map simplifies the relevant landholding groups into tribes holding sovereignty over bounded areas, and that our attention, and Jitendra has drawn us to this, needs to be focused much more on local groups and their connections to country. But I think in Queensland and other parts of the country, and probably even in the Northern Territory, what we find amongst contemporary people today is a representation of the issues in terms of these tribal labels, X and Y, and we can have contradictory statements being put by contemporary people, which may, not actually take us to the label Z recorded by Tyndale or someone else in the ethnographic record. So how have anthropologists approached this in terms of thinking about historical change and succession? Well, Jitendra has taken us to some of these issues, but it's particularly been addressed in Northern Territory context, and this is a useful source. Unfortunately, it's a difficult to find source. I think it was published in the proceedings of the Commonwealth Parliament rather than in an anthropological journal, but it is available, and it focuses on succession to clan estates where the original owners have died out. And Peterson, Ian Keane and Basil Sampson discuss the ways in which what the authors call secondary rights, and we can see that Northern Territory land rights language in there, gained by place of conception, birth, death, burial, kinship, and so on, being transformed into primary rights. And you've seen detailed discussion of that in the former presentation. It also focuses on succession events, you know, where there's a planned and organised and remembered transfer of the title deeds of the sacra for the country that people can then talk to and narrate as indicative of the completion of a succession process, while, you know, life cycle events also being relevant. So we have some discussions like that. Peter Sutton summarises that discussion in Native Title, his book, while also talking about the ways in which succession on a more collective basis may occur beyond a clan estate level when things like catastrophic population collapse results in vacant country. And I think that this was certainly common enough in the context of colonisation and places like Burketown, which were affected by one of those Queensland fevers, you know, suffered pretty severe population decline and collapse in the in the early years of colonisation. But I think we can assume that it was also occurring prior to colonisation, and that there were times when the orderly transfer of sacra and the organising of the title deeds to be passed over to somebody else, you know, simply didn't have time to occur. So how does that, what are the systemic bases upon which that takes place? And Sutton identifies some of the lists that Jitendra's taken us to, such as territorial proximity and systemic grounds for territorial amalgamation, while noting that there would be typically much simplification of the cultural knowledge of those areas in contexts like this. And I think Professor Sutton is particularly thinking about David Trigger's research there with Gungalita at Burketown taking over or succeeding to country of Minganda-speaking people, and Wanyi people succeeding to country of Nubarindi and other groups in Queensland. And Trigger's at pains to distinguish his case material from the sorts of Northern Territory examples that we've seen in talking about more informal processes whereby succession becomes assumed over time in the context of a regional body of shared traditional law and custom, without necessarily a form of institutionalised decision-making about the organised takeover of country, you know, which is simply not in that Gungalita material. People tend to say that it's, you know, it's always been Gungalita country, Burketown. And Minganda, you know, Gungalita people, well, today probably don't talk particularly about Minganda, but in the earlier days would talk about it as a subset of the Gungalita language, or that, you know, it wasn't, there wasn't a perception that the country had ever been anything other than Gungalita country. And so for Professor Trigger, that's an indicium, I think we would say, of completed succession, that it's forgotten, right? So how do you then demonstrate that it's occurred in the context of situations where it's been forgotten, and that those processes were licit or were legitimate according to the traditional law and custom of the incoming group, but also, as Jitendra has also pointed out, the traditional law and custom of the original group. The succession event has to be considered to be legitimate by the original group in the country so that the law stays the same, if that makes sense. So it seems to me that that implies that, yes, you have a shared system of traditional law and custom which unites both of those groups, and that you have some processes that would govern that. And our colleagues there, Professor Trigger and Professor Sutton, have done a wonderful job of taking us to the relevant points, but I wanted to pull out this quote from Lauriston Sharp talking about Euront people, which I think puts it beautifully and in a sophisticated way, when he writes, "If the human membership of the clan becomes extinct, the other elements of the totemic complex of the clan may continue in existence for a generation or so." So if the human membership of the clan becomes extinct, you know, what's he saying? Well, he's saying that the clan is not just the living people who are in the country, it's the broader totemic complex of dreamings and totems and spirits and so on. The relationship of the land to the ancestors, totems, rites and other totemic traits being consciously retained in the memory. It will be pointed out in the discussion of ownership, however, that another clan usually assumes control of the domain of the extinct clan and that the control gradually becomes fully fledged ownership. So this to me is a helpful and succinct and, you know, a somewhat, you know, I use the word beautiful, evocation of what we're actually talking about. We're talking about well, we call it law and custom in the legal context, but the dreamings and the totems and the richness of that country being remembered by, you know, neighbouring groups along the track of a dreaming, for example. Well, we know our dreaming goes over there. We know that it was originally the country of another clan, but you know, we're part of that same story. And that was significant then in thinking about the Kurraja example, where we had lay evidence about people coming to join the Kurraja group. Historically, we had oral histories of individuals who were thought to have come from the east, and in the early days or in the wild times to have joined with Kurraja people. With the work of people like Sharp, it was possible to demonstrate that the shared laws and customs united the people of that country with the Kurraja group. But in the absence of remembered succession events, there were other indicia of succession which were significant, such as knowledge of the dreamings in the area and all the rest of it. Knowledge of the country. There were some helpful examples of conception, filiation, the finding of baby spirits in places. But above all, it was significant that claimants were confident in the exercise of their traditional laws and customs in that area. And as I try and remind our students, if you believe in that there are serious spiritual consequences of breaking the law, and you believe that the law is in that country, then you need to, you know, that's real to people. It's not a story, and people who are confident in the exercise of their rights and interests in the area itself attests to their understanding and ability to manage and to interact with those spiritual presences in that country, which the Kurraja people were able to demonstrate in the hearing of the lay evidence on country. And so the judge, Justice Raries, had what I think is a helpful summary of all of this and accepted the evidence that it's relevant, in fact it's critical, that a critical test for whether succession has occurred is whether the incoming group is confident in its ability to manage those spiritual potencies of particular areas of land and waters, and in repudiating the evidence of one of the other experts who'd said, well, no, you need these discrete remembered events where the transfer of the title deeds to the country took place. The judge found that the prescription of some checklist of criteria to establish that licit succession had occurred may involve an inapposite concentration on form over substance. So I think it takes us to a different example than some of those Northern Territory examples, and the helpful notion that the confidence in the exercise of rights and interests and the ability to manage that country is itself a relevant indicium of succession. So I'll end there with time for questions.
We've got about 10 minutes for questions, so Meredith, it's up to you now. And would you like to come and sit up here to tender? There's a question from Dave.
Thanks, guys. My question, I suppose, is for either of you. But Jitendra, you mentioned in your talk about coming to a claim sort of a bit late in the process when they've already set up boundaries and claim group, and you've got to kind of work within that framework. If you come into that situation and your opinion differs from the way they've set up the claim, how do you address that? How do you deal with that scenario?
Well, I think your opinion has to be your opinion. Like, if you disagree with it, how it's formulated, I think you're bound to give your opinion straight. So, for example, those claim group descriptions or things about membership of a group very rarely has that qualifier, how people drop off. And I might say, I think I mentioned in the comments earlier, that to be a member of the group, dissent on its own is not enough. It's not sufficient, because you need something else, and that something else can be participation in the social life of the group. And then it's up to the group to determine whether someone fits in or not. It's not something that you can just have a group coming down from an apical ancestor. I think if your opinion differs, it differs, and then it's up to the group and their lawyers to sort that out. I mean,
and so in that scenario, have you got any experience? Have lawyers sort of thrown out your report and not used it if it has a different kind of claim description, or do they still use it and rely on the bits that they agree with? Or
I'll tell you in about 6 months when they get back to me. But yeah, in some claims they have, and but the current one I'm working on, which I didn't mention, that's an issue. Yeah.
Just a quick question about succession when there are neighbouring, or a successor group and a group in dispute. Are there processes of triangulation to assess from other groups about whether or not there's an acceptance of whether succession has taken place?
Thanks for your question. I think it takes us to the most difficult aspect of succession, which is succession in the context of intra-Indigenous disputation. And I will say a few things, but I think that part of the evidence of succession, as it's written about, for example, by David Trigger, is that it's accepted within a broader regional system of law and custom, and that, what I think is sometimes unfortunately put as the general public kind of accepts that, okay, those are the right people for country. And Kevin Smith, the president of the tribunal, noted in one of these last events that 50% of our outstanding claims are subject to overlapping claimant applications, so there are intra-Indigenous contestation or you know, there's differences of opinion, if not outright disputes. And as to the proof of succession in the context of disputation amongst Indigenous groups, I think it will be a difficult. In the Kutja matter, we had the neighbouring group speaking up strongly in support of Kutja succession to that area, not that they described it as succession. They said, well, we know that's Kutja country, and you know, our old people were welcomed onto there by the people. And I mean, had there been disputation amongst that group, I think it does take it to another level of evidentiary scrutiny, and I'm not sure that there's much case law about that would help us answer that question as to how it might be resolved. I think you would go to the connection to that area and do your best to understand that connection and its traditional basis, and it may be possible to emphasise that one or other of the groups has a stronger connection that's more clearly grounded in traditional law and custom, but it's an obvious problem that will increasingly come up, I think.
I don't really have anything to add to that. Wendy, you're here.
Just in defence of the Northern Territory, I'm currently reading... Sorry. In defence of the Northern Territory, I'm currently reading Justice Mansfield's recent judgment, where he says, as briefly noted above, the question of succession under traditional Aboriginal law is not a straightforward one. The general tenor of all the evidence, both from Indigenous witnesses and from the anthropologists, is that an evolutionary process. Part of this judgment is actually looking at a particular group who are assumed to be extinct. They put forward a case that they actually are not extinct. They were recognised by the judge, but part of the evidence was about the jural public, and there were a number of cases where there was a particular event, but the judge and the evidence made clear that this was perhaps a crucial event, but it was being led up to through generations or through decades. So I do want to say that it's not as straightforward as, oh, there was just a handover of sacred objects that makes a succession complete. That's obviously not the case. It takes generations, no matter where you're from.
Sorry, maybe just a comment and then a question. I was lucky enough to work with Jitendra in that matter you referred to, but also the neighbouring one. And I think going back to some of the comments the judge was making about basis and opinion, what was really helpful when the state, I think, struggled to understand some of the concepts outside of just plain old dissent for the acquisition of rights and interests was the way you framed your supplementary report that really set out the basis before forming that or clarifying or for the state your opinion around those other factors that can lead into acquisition of rights in country. So that was really useful, but I think the state lawyers struggle, especially in Queensland, when they think of, or they're so used to, I think, language-based, what they think of as language-based claims. And the second thing I think was probably around the disputation. Or any tips about how we might be able to assist groups manage or understand some of the concepts you're talking about, even though it's part of their traditional system, if they may want to use some of those concepts or not use some of those concepts for political reasons?
I think what you're doing in your areas, which is to do the sort of regional research before lodging claims, I think that's one way to avoid dispute. And I think, as you know, I don't know how you explain it, because because people get very offended if they think you're trying to explain their laws and customs to them and they disagree, right? So I just think it's really difficult. But one way, with those cases I mentioned where there's clear evidence of incorporations having happened in the past, is to go through the genealogies and the evidence that's there and show that this has happened, but everybody still thinks that person belongs to, one country or the other. So I think that's one way. But a lot of disputes happen because claims are put on before all of that discussion has happened. And as you know, just for background, the URI claim, so I did 2 claims with QSNTS that are neighbouring, and there were disagreements between the 2 groups about where their boundary should be. One group thought the other group was actually, should be included in their claim. But in the end, it was a pragmatic call about where to put a boundary, and that just took a lot of discussion. But as far as I know, Sherry, and maybe this has changed, that boundary hasn't been disputed, although there are other issues with the claim. So I think it's doing work beforehand, which the land councils in the NT do really well, which is you don't just lodge a claim, and Wendy, I think that's right, isn't it? All of the research happens before the Form 1. So all those issues can be discussed beforehand. You would have meetings where the findings are presented and argued, and all of that happens before a list of apicals and like those sort of Form 1 sort of standardised descriptions happen in the Form 1. Sorry.